I'm Rebecca Secord. I'm an estate planning and real estate attorney located in San Diego, and I work with people all over the state of California on their real estate and estate planning needs. Today, we're here to talk about finally doing the thing. And what is that thing? It's estate planning for you parents, the ones that have minor kids. A legal disclaimer, because I'm a lawyer and it wouldn't be a presentation without a disclaimer. The lawyer stuff, none of this is going to be legal advice. This is just information, primarily because if you're not a client, I can't give you advice. I need to know more about you. I need to know about your situation so I could tell you like, yeah, this is the thing. At the end of this presentation, there'll be an opportunity to ask questions and I'll answer them to the best of my ability, but it may not be specific to you. Why does it depend? And it's again, because we don't have an attorney-client relationship and I don't want to lose my license because I gave you advice. And the other thing to consider is that it's 2025. And when you're watching this on a replay, the information included might be outdated. So also keep that in mind if you're watching this in the future. And again, a little bit about me. So I'm Becca. I'm a queer estate planning attorney. I'm in San Diego and I work with people all over California. I play softball. I paint. I have a kid. That's a picture of me and my kid. She's 10. I somehow have managed to keep her alive for 10 whole years. Oh, we also have two crazy cats named Dante and Miguel. And they're weird and wild, and I love it. So whether you're here to explore or support or connect, I just want to thank you for being here. All right, so what's estate planning? Well, I'll tell you what it's not. It is not just for the rich. It's not just for old people. It's not just for people who have real estate or people who just have kids. It's for everybody. If you have a pulse, you need a plan. And what does it do? Well, it answers these three questions. And if you can't answer these three questions, don't worry, your estate plan will help you do that. It helps answer, what about me? What about my stuff? And what about my kids or the people that I care about? So you matter. Whether you think so or not, you matter. So does your story. The what about me part of estate planning is the what happens to me if I can't do things, if I lose capacity because of age or injury or health issues, who's going to be making decisions for you, whether they're financial or whether they're health decisions. If you don't have a plan, your people will be in court. And that's a conservatorship. And you can think of that like Britney Spears around 2009. Her family petitioned the LA Superior Court for conservatorship, not only of her money, but also of her person. So she can't make any decisions about herself, literally anything, without the conservator being involved. It's also super public, really expensive, and it's almost entirely avoidable. There's a little bit on the conservatorship. You might end up in court anyway because you're so obstinate that you won't agree to go into care or get treatment. We'll talk about that another time. So your estate plan is really about core 4 documents. And these are the things that everybody needs, but not a lot of people have. When it comes to parents, there's going to be some extras, and we'll talk about that in just a minute. But there's your will. That's what gets filed at the probate court that says, here's who I am. Here's who I'm married to. Here are my kids. Here's what I want to happen to all of my stuff. A lot of people think a will is enough. A will is a one-way ticket to probate court. The other part of this is your revocable living trust. And this is applicable for most people. If you don't have a taxable estate, don't worry about that. A revocable trust is generally going to be the best option. And what this does is that it keeps you out of probate when you're dead. But more importantly, it's also a living trust for a reason because it works while you're still alive. It allows continuity of management, essentially, for all of the things that you have, whether your bank accounts, your retirement accounts, your brokerage, all of the things that you have, somebody's going to be able to pick up the reins, whether it's your spouse, a friend, a sibling, a trusted person in your life, or a professional fiduciary. They're going to be able to pick up the reins if you can't and continue to manage your life, even if you can't. In relation to your revocable trust also deals with the what happens when I die. Right? You make provisions for your spouse, you make provisions for your kids, all sorts of people. A lot of control rather than just leaving it to either the law or to a will that's going to be public. The other part of your estate plan includes your financial power of attorney and your healthcare power of attorney. Your financial power of attorney basically is one of the most powerful documents in your entire estate plan because it allows your person to step into the role of you. They can do almost every single thing that you could do while you have capacity, with the few exceptions that there are things that they can't do. But for the most part, anything that you can do, your power of attorney can do. Your advanced healthcare directive is sort of in that vein of your financial power of attorney, except it deals with you. It allows that person to make medical decisions for you, and that includes everything relating to If you have the ability to become pregnant, it talks about, that type of care. It talks about end of life care, donations. If you've got special wishes, you can put all that stuff in there. Why does it matter so much for parents? And it's pretty simple. It's your kids. The default rule in California is that minors can't inherit, at least not right away. If you die without a plan, the judge is going to decide who's going to get what, who and when is going to get what. And generally, the kids are going to receive their inheritance when they turn 18, no strings attached. So if you've got a sizable estate, your kid's going to get all that money at 18. And I'll tell you something. At 18, their prefrontal cortex, this is the really important decision-making part of their brain, is not fully formed for almost another 10 years. And if you're a boy, if you have boys, it's even worse. Right. So we want to do our best to make sure that we protect our kids from themselves, not because they're bad kids, but because their brain doesn't know how to deal with stuff. You have zero control over how they inherit, what they inherit, who manages those assets while your kids are still minors and beyond. And then you also have zero control over who raises your kids. If you don't have a plan, your family's going to be in court because someone has to raise those kids. Let's shift gears and talk about your stuff. What happens? And there's a lot of words on here. Don't worry about it. But the general rule in California is that married people have two types of assets. They have community assets and they have separate property assets. Talk about separate property first. Separate property is stuff that you're bringing into your marriage. So stuff that you acquired prior to getting married. It's also stuff that was gifted to you or stuff that you inherited. That's separate property, unless you do something to change the nature of it. Community, those are the assets that you acquired during your marriage. So that's income, that's appreciation on your investments. Those are your business assets. Those are your business reputation. All that stuff that you acquired during your marriage is community. And unless you have an agreement that says otherwise, and that agreement would be a prenup or a postnup, it's community. So what happens when you die and you don't have a plan? Well, up here are the default rules. If you have a kid but no spouse, we talked about that. Your kid's getting everything. A judge is going to decide, what to do with all of those assets, and then they get it at 18. If you're married and you have one child and that child is of your marriage, your spouse is going to get all of the community and half of the separate assets, and your kid will get half of the separate property. It gets more complicated the more people you add to the mix. So if you have a spouse and multiple children, the spouse gets less of the separate property and the kids get more. If you have a spouse, but you don't have any kids, but your parents are still alive or your siblings are still alive, those people can inherit too. They'll get half of your separate property. And these default rules might not be what you want. The biggest part is making sure, especially when we're talking about our kids, is making sure that our kids have appropriate access to money. I said earlier that if you don't have a plan, there is one for you. We also have to talk about how expensive probate is in California. It's super expensive and it is super avoidable. So the magic number, $184,500. If your estate, and we're not talking about real estate right now, we'll talk about that in a second. If your estate is valued at $184,500 or less, you can take advantage of something called the small estate affidavit. It's a streamlined process, not as expensive, not as time consuming. But most people in California are not going to fall under that. In April of 2025, new law went into place that allows a primary residence to be included in that small estate, so long as the value of the primary residence is $750,000 or less. In most of the metro areas, no way. No way. Most people, the average home value in California is over $750,000. This is going to be really helpful for people in more rural areas, but $750,000 in a primary residence, that will not include investment property. So if you've inherited real estate from your parents, you have investment real estate, it doesn't matter. If you have that, we're going to drop down to this bottom part. But your primary residence, for most people, this won't apply. It's great and it will help a lot of people, but for the most part, it's not going to. You're going to end up paying full probate fees. And that's what this lower chart is. When they're looking at the value of your estate, they're looking at the gross value. So if you own real estate and you have a mortgage on that real estate, they don't care. So if the property is worth $1 million and you have an $800,000 loan on that property, they're not going to look at that as a $200,000 asset. It's $1 million asset. And they're going to calculate how much your probate fees are based on all of the stuff that you have. So you have real estate, you have your bank accounts, you have the stuff, your stuff, the clothes on your back, the things that are in your home. If you have restricted stock units through your employment, if you have accounts that are beneficiary accounts with no beneficiaries, all that stuff ends up in probate too. And it all goes into the calculation of how much are we going to be paying in probate fees. So for an easy, nice, easy round number, $1 million. Not that hard to hit in California, especially if you own real estate. Statutory attorney and executor fees, $46,000. $46,000 that you're going to pay to well, you're not, you're going to be dead. Your family is going to pay $46,000 to an attorney and to the executor of the estate. And that's step by statute. As you go up in how much you're going to pay. A $5 million estate's looking at $126,000 in probate fees. You could do your estate plan several times before you come close to paying the statutory fees for probate. So something to consider is that it might feel expensive now. It will pale in comparison to what your family will pay, not only, like right out of pocket, but probate in California, it's at a minimum, a full probate, you're looking at a minimum 1 year process. Most times it's 18 months to 24 months, and that's uncontested. Throw in a contest, somebody's fighting about something, going to take even longer. And it's just a drain on resources. There we go. So what about the kids? We'll talk about, this is why we're all here. We're here because we have kids. If you don't have a plan in place, your kids will be placed where is necessary and proper. Where is necessary and proper? Who's going to be making that decision? A lot of times, especially in a situation, let's say you're driving home from work, you get into an accident, your kid's at daycare. Who are they going to call to come get that kid? Or your date night, right? You're out on date night. Who's the knock on the door? Babysitter answers the door. It's the police saying, mom and dad were in a car accident. We have to take the kids. Where is necessary and proper is what's in the best interest of the children. And that may not be what you think. More often than not, if there's not a written plan in place, they're going to end up in foster care until a court can decide who's going to be a guardian, whether it's temporary or on a permanent basis. Your kids don't want to be in foster care. You don't want your kids in foster care. Foster care serves a really great purpose. This is something that we can avoid by having a plan in place. So how do we avoid court? Your estate plan. We talked about the Advanced Healthcare Directive. This is who gets to make those healthcare decisions for you. And we can get super granular about what type of care you want to receive, how you want to receive care, what type of doctors you want to see, what type of doctors you want to receive care from. Maybe you don't want to receive care from doctors. Maybe you want to use alternative care. You can get really specific about what you want. The person that you want to be naming for this is someone that's going to be able to stand up to a doctor and say, no, that's not what they wanted. They want this. You also want somebody that's going to actually abide by your wishes. If you say pull the plug, you don't want somebody that's going to be waffling over, do I want to make this decision or not? You're also giving control to your person, especially if it's your spouse or your kids or your parents. You're telling them very specifically, I don't want to be on life support, or I do want to be on life support. You don't have to worry. You can take the burden off of them for having to decide, do we take them off of life support? Because that is a decision that if they have to make it, they will have to live with that decision for the rest of their life. And it's not a good feeling. The other part of it is about organ donation. Your family does not want to get that call at 2:00 in the morning asking, can we harvest their organs, right? Having some specific instructions about what can and can't be done with your body is going to be really important to maintaining the sanity of your family. The power of attorney, again, keeps you out of court, right? And we have two different types. We have a durable power of attorney that turns on and off with incapacity. And we have a statutory form, which we only use for spouses, at least at our firm. And what that does is it's on. So it allows your spouse to pick up the reins immediately. You don't have to be incapacitated, but if you are incapacitated, it really cuts down on the amount of time that's needed for that spouse to act. The thing that when we're working with parents, the nomination of guardians is generally what people spend the most time on because it's so important. Who's going to be raising these kids? And we're going to talk about it. Who are these people? What are they? Do they align with your values? Are they good with your kids? They don't necessarily have to be the same people that are dealing with the money. If you've got a family member, they're best parents ever, but they actually have no idea what to do with their money, that's totally fine. You can separate those jobs. But the other thing is we want to keep this private. The very beginning of this, we talked about how the will is public. And you go through and you identify everybody, your spouse, your kids, the guardians of your kids, who's going to be in charge of the money, who's getting what. When it comes to naming guardians for your kids, we don't do that in that document. We say, I have 2 children. We don't name your children. And in the provisions about your guardian, we're making a separate provision for your guardian in a standalone document. And it's not just a little document that says, okay, pick this person and then this person and then this person. That's in there, but it's also my favorite part, which is the manual that you wish that you had when you had that baby, when you brought that kid home. This is the gift that you get to give to your guardian that says, if I was able to be here and raise my child, this is what I would want. So it's your parenting philosophy, it's your family traditions, it's if your kid has a special needs, like let's say they have a 504 plan or an IEP at school, you get to put that in there. You've got a kid that has autism. Here are the things that work. Here are the things that don't work. You get to tell your kid's story in there. So you give basically a playbook to the guardians to say, hey, this is how you can do it. They're going to be the parents. So at the end of the day, they're going to have the decision making. They can do what they want, but it really empowers your guardians to raise your kids the way that you would want them to. It also helps a judge appointing the guardians, because as important as it is to name the people to take care of your kids, it's equally important to name the people you don't want to take care of your kids, because there may be people in your life that you're like, I love you, but you're an absolute dumpster fire when it comes to kids, or you don't align with my values, or fill in the blank, whatever reason it is that you wouldn't want somebody to take your children. We can put it in there that says, under no circumstances are these people to be the guardian of my children. And that goes for all of these documents, whether it's a power of attorney, an advanced healthcare directive, or a successor trustee of your trust. We can carve out these provisions for people that can't be doing these jobs for whatever reason. And then again, how do we avoid court? Your revocable trust, right? Your will still has to go to the court, but we keep it private. When you have a trust, what your will says, instead of this is me, this is my family, this is all my stuff, your will says, don't worry about it. Everything that I have at the time of my death goes into my trust. Call it a pour over will. You literally take everything that you haven't already put in there and you dump it into your trust. And don't worry, judge, we're going to privately administer it. Okay. So your will still goes to the court, but we don't actually have to do a probate. You have your trustee and they administer everything. We have a lot more control over what happens. We have a lot more control over, especially when it comes to your kids, controlling access to funds. They're not just going to get an outright distribution at 18, right? And as your kids get older, like maybe things will change, but what happens is that you have so much more control over who's going to be managing those funds, what can they use those funds for, and when can my kid actually start pulling funds out of this trust. If you're dead, you don't get any control over that. And this really gets, what your values are. It's going to align with what your values are. If you want your kid to be able to spend their money on traveling, put it in there. If you want them to spend money on education, it's going to be in there, but you can put a lot more customized terms in about what do you want your kids to have access to. And then the other part is making sure that you fund your trust. So while I say that you're going to be able to stay out of court, doing the documents, doing this part is probably this is the biggest thing, right? That's why you all are here, because you don't have a plan, right? It's on the bottom of everybody's list, especially parents, because we're all living life here. We've got kids, we've got jobs, we've got spouse, like literally everything comes on top of your estate plan. And it's always there right at the bottom of the list. Do my estate plan, right? When you actually get to the part where you're here, you're doing your plan, you have your plan, it's great, but you have a little bit of homework after, and that's making sure that your assets actually end up in your trust, because you might end up, well, you might not be, because again, you're dead. Your family's going to end up in court to clean up that mess. So how do we fix that stuff? Well, those documents, it's not quite it. Like, that's not it. Like, we have other stuff to do. When you're working with us, we also work on other things like your insurance. As an attorney, I swear I never in a million years, as a dirt lawyer and a death lawyer, I never thought I would be talking about insurance as much as I do. And in California, especially over the last like 3 years or so, that's all we talk about is insurance. Because if you don't have proper insurance, or you don't update your policies, especially once you've done your trust, if you haven't updated your policies to make sure that your trust is included in this, you don't want to give the insurance company a reason to deny your claim. So we're always talking about insurance, making sure that you have the right type, making sure that you have enough coverage. And I can't tell you if you have enough coverage, but you go talk to your broker and make sure that happens. But making sure that you've got the insurance to cover all of the things. Real estate's my special flavor. And when you own real estate with somebody who's not your spouse, things get real messy real fast. So we're always talking about how do we manage that risk? How does that real estate portfolio play into your estate plan? And the people that you're in business with, how does that affect them? How does that affect you? And then we also work with your team, because what we do in your estate plan, think of it like a wheel. Your estate plan is right at the middle, because this thing right here is going to control everything else. And I want to know who else you're working with so that our plan, your plan, aligns with the goals that you have in your business. If you have family law, if you have a prenup or a postnup or whatever, making sure that all of your things are aligning. You have a financial advisor, definitely want them involved in all of this. So how do you get started? Well, you already made the first step. You're here. It's not as scary as it sounds. I know we talk about death a lot, but really it's about living, because you're here, you're alive, you have a whole lot more living to do. So do your kids. We make this a really approachable process because it can seem like a lot and it can seem overwhelming, but we break it down into more digestible parts. So we generally meet over 3 to 4 meetings, where I have a learning meeting where I learn all about you. You have a learning meeting where you learn all about the stuff that we just did. Like, what did we just draft? What are these documents? How do they work? We make sure that the things that you want and the people that you want still work once we actually look at this thing. Once you've approved your documents, then you get to sign everything. And when I talked about funding, that's our last meeting. That's a congratulations, you just did this big, scary, crazy thing. You're done. Here's what you need to do next. Again, it's collaborative. I want to know the other people that you're working with, because if there are other things going on in your life that are going to affect your estate plan, I need to know about it so I don't make a plan that's not going to work. We're entirely virtual, which allows us to work with clients all over the state of California. We meet over Zoom for all of our meetings. And then when you actually sign your documents, you don't have to do this in person. We work with a remote online notary company that you can be in your pajamas for all I care, on the couch eating, a bowl of cereal. Don't care. The notary will walk you through and have you sign all your documents, and you're done. It's like a 15-minute process, and it's cool. Some tips about working with an estate planning attorney. You want to work with an attorney that aligns with your values. There are so many attorneys in this state. You have a pick of the litter of people that you want to work with. Work with people who align with you. You don't have to work with them just because they check, fill in the blank, you were referred to them by somebody. Referrals are great, but if they aren't your people, you don't have to work with them. Do they work with your team? I am not kidding when I talk about the team. Teamwork makes the dream work. My kid and I say that to each other all the time, right? It's so important that your estate plan aligns with the goals that you're doing in all of your other areas of life. We want to make sure that you're working with a team. And then, do they check in on you after you're done? I mentioned earlier, this is not a one and done type of situation. You don't set and forget your estate plan, because life is changing. The life you had 5 years ago, 10 years ago, 50, it's not what it is today. And it's certainly going to change in the future, right? So you want somebody that's going to check in on you in pretty regular intervals to make sure, hey, what's going on? How are things? Right? Because maybe your kids got older. Maybe the people that you named as your trustee or your guardian, something happened with them, and oops, we need to update those things. Or maybe your plans have changed. Maybe you moved out of state and you moved from California to, I don't know, Virginia or, wherever. Did you do a plan there? Oh, you haven't. Okay. You probably should talk to it out, wherever you're living, you need to get a new plan, because again, this might not be enough. So you just want to make sure that somebody's going to actually check in on you. Who do we work with? You. We work with you. We work with people in the LGBTQ community, parents, people who are kid-free, people who own real estate, people who don't own real estate, people who have businesses, people who don't have businesses. If you're single, married, divorced, come as you are. Especially in the single, if you're single and have children, that is super duper important to make sure that you have a plan in place, because there is no one else, unless you specifically name them, to step in, right? It's a lot harder if you're single. And then there's just different planning that has to go in if you're single, especially if you're single and you don't have kids. They are my favorite, because y'all have there's just so much planning that we can do on who gets your stuff. And then if you're divorcing, that is a really interesting area of estate planning, because there are certain things that you can and can't do while you're divorcing, but it's super important that you talk to an estate planning attorney while you're going through that, to find out what can you do, what needs to be updated while you're getting divorced, because you don't want a situation where your soon-to-be ex can make decisions for you, especially if you have any documents already in place, like a power of attorney. Okay, that ends the content portion. If you want to make an impact, you can donate to an organization that I hold near and dear to my heart. And actually, don't click that QR code. I'll send it to you later. Townspeople is I sit on the board of directors of Townspeople. It is a 40-plus-year-old, I think I actually started in 84. So 41-year-old organization that's based in San Diego that provides permanent housing to people who are coming out of homelessness. And we do that through a variety of opportunity. We have property that we own and manage, but we take people out of homelessness and provide them permanent housing and provide supportive services to them. If you donate $100 to Townspeople, we'll take $500 off your plan, and then you just have to book by September 15th. If you are outside of San Diego and you still want to make an impact, donate to an organization that's local to you. Send me proof, still give you the $500 off. And with that, this is me. All my contact is on here. There's been a QR code that's been floating around on the bottom. That'll take you right to the booking link so that you can schedule your complimentary 20-minute consultation. Or you can just shoot me an email or give us a call. My people can schedule your appointment whenever works for you.